Welcome to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls.
Welcome to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. Melanie is an OSBA certified specialist in family relations law who helps individuals and families resolve complex financial and parenting matters with clarity and structure. I'm Leanne Lyon, and today we're diving into an important discussion on custody battles versus custody solutions in Ohio. Hello, Melanie.
Hello, how are you?
So good. And very happy to be here again. So, Melanie, in your experience, what are the most common triggers that turn a custody discussion into a full-scale battle rather than a search for a solution?
I think sometimes it's the mentality that a parent approaches the situation with. For example, it's not about what's best for the child, it's about winning. Winning is not the right approach. It should be, what works best for my child. Sometimes you'll see parents with new romantic partners or a new spouse that is really driving the bus, and it's not actually the parent pushing for this, it's their new significant other or their new spouse, or they're interfering in the communications between the parents. An example of that is text and email communications. You've got a parent texting the other parent, and then you have their new spouse or their new partner texting back. Sometimes you can figure it out from the verbiage, hey, that's not the way my spouse words things, and it's the other person, but that can really cause things to go south and take a small matter and escalate it when you've got the third party sort of interfering or driving things. Another aspect of parenting that really tends to cause parents to escalate is finances. If you have an agreement in your shared parenting plan that the parents are going to split extracurricular activities 50-50, and you have one parent that hasn't paid their share of expenses in 6 months or a year, then that really starts to build resentment because the other parent is paying for everything and not getting reimbursed. So those are typical ways that you can take a relatively low-key situation and turn it into a battle.
I know you've mentioned using law as a therapeutic profession. How does that mindset change the way you represent a client in a heated custody dispute?
Well, I think I try to look for solutions instead of head straight to litigation. I mean, litigation should always be the end result when you've tried everything else. It shouldn't be, let's litigate right out of the gate. For example, if there are communication issues, have you tried our Family Wizard? It's a great communication tool. If you're having trouble with child-related expenses, you can upload the expenses to our Family Wizard. If you're having scheduling problems, you can use the shared calendar where you put all the child's activities and appointments on a central calendar. If you and the other parent aren't communicating, have you tried co-parent counseling? Have you tried co-parent coaching? Are you in therapy? Is the other parent in therapy? Those are all things that should be asked. Now, you may have a client who says, I don't want to do that. I just want to go to court. But I think that is a last resort, and you really need to try other avenues before you litigate.
When a parent's version of best interest is actually a personal vendetta, how do you provide that necessary reality check to protect their legal standing?
I think there are a couple of different ways. Sometimes you repeat what they're saying back to them and say, this is what I'm hearing you say. you think is best for your child? Is that really what your goal is? Or do you really think that that is the right path to take? Or what about this path? Or the role reversal, which I like a lot. You know, you're going to be the magistrate, I'm going to be you. Here's what the magistrate's going to hear. What would you rule? Here are the best interest factors. How would you rule if you heard a parent say this to you? And here's what mom's going to say. Here's what dad's going to say. You're the magistrate. Okay, tell me what you think. What would be your decision hearing those facts? And it really does work, because I think parents come into the process with a little bit of tunnel vision. You know, they see what they want to see, they see what they think is best for their child, and they haven't looked at the big picture. And sometimes when you do the role reversal, they have to look at the big picture. They have to look at what they're asking for, what the parent's objection or counter to that would be. And I think it helps open their mind up to some better solutions than just what they came into the office with originally.
Well, you are a trained parenting coordinator. How does this role help high conflict parents bypass the courtroom and help find solutions on their own?
As a parent coordinator, I think one of the most important things is to think outside the box, because you take mom saying one thing and dad saying another thing. Well, obviously, they've already tried and failed at coming up with a solution. So you really need to provide them with other alternatives. You know, why I hear you saying this, mom, and I hear you saying this, dad, but have you thought about this? Or, have you thought about that? Or how about, this is an alternative? You really need to broaden their perspective to other options versus the ones that they've tried to reach an agreement on and failed. So I think it's helpful to bring in, an outsider, and it's a fresh perspective. And I think that helps them reach a resolution.
Well, if you have one parent who is really determined to battle, perhaps due to a high conflict personality trait or some other factor, how can the other parent stay focused on solutions without being steamrolled?
I think that a couple things. When you receive what we like to call a zinger, or an email or a communication from the parent that would tend to cause you to react either in anger or to lash back out at that parent, I like to use the 24-hour rule. Type up your response, sleep on it, read it again, edit it, and then send it. Don't immediately respond, and as soon as you get that email or as soon as you get that text, send one out to them, and then you're in a text battle or a text war, and that doesn't get you anywhere. I've found that the parent that remains calm and measures their responses usually ends up with the upper hand, because the other parent gets frustrated, they continue with their anger, they're sending irrational responses, and the calm parent is measured. Their responses make sense, their responses are in the best interest of the child, and those will hold a lot more weight with the court. If you're at trial and you have 20 pages of text messages back and forth, with one parent being very abrasive and irrational, and you have the other parent remaining calm throughout those 20 pages and always responding with answers that are in the best interest of the child, the court is going to really give that parent more deference and more weight when it comes to making a decision.
Ohio courts often prefer shared parenting. What are the hallmarks of a solution oriented shared parenting plan versus one that is just a temporary truce?
What I tell parents about shared parenting is our goal as an attorney is to make sure you never have to go back to court. If your child's 4 years old, this document is going to take you until they're 18 and graduated from high school. Some parents like to say, oh, we're getting along. That's never going to be an issue. But my response is, well, if it does become an issue and it's not in your plan, then you're going to have to file a motion and come back to court. And we don't want that. So why don't we just go ahead and put it in there? A lot of parents don't think about, if they've got a 4 or 5 year old, they don't think about a passport. Well, you know what? When your child's older, there may be a school trip to Italy or some other country, and they might need a passport. Well, what if the other parent won't comply with the paperwork to complete the passport? Or let's say you do have a passport for the child, and one parent holds on to it and won't give it to the other parent. Typically you'll say the parents alternate holding the passport. The parents will not unreasonably withhold the passport. You can put language in there that the child will not travel to a country that's, rated a certain safety level, or that doesn't recognize the Hague Convention. So you can put all of those things in there. But a lot of shared parenting plans are just the bare bones. Here's our parenting schedule. Here's what we're going to do on holidays. Here's the parent who's covering the health insurance. And this is how we're going to do the tax deductions. And it's just not, I think the more detailed it is, the better off you are, and the less likely you are to ever have to come back to court. And I think that is the most, it's the strongest, and it's a proactive plan versus a reactive plan where you kind of just did a skeleton plan and you're hitting bumps in the road with the other parent and you're having to file a motion because that issue was not addressed in the plan.
From a legal specialist perspective, what is the hidden cost to a child when their parents choose a multi-year courtroom battle over a mediated settlement?
Well, protracted litigation is never good for a child. They don't know. It causes them anxiety, the uncertainty. I don't know what my schedule is going to be. I don't know whether I'm going to be week on, week off. Am I going to be Monday, Tuesday with mom, Wednesday, Thursday with dad? Where am I going to go to school? Am I going to be able to play soccer? Their whole life is kind of on hold and uncertain while their parents are battling it out in court. Now, if they've gone to mediation, everything could be resolved, and the child can relax and focus on being a child instead of having to focus on mom and dad fighting, feeling caught in the middle, being the tug of war of loyalty, of worry about making mom happy and making dad happy and not making mom mad and not making, dad mad, and being caught in the middle. A child should never feel caught in the middle of their parents. And these parents that don't want to come to the table and resolve it and spend years in court, it really is unfair to the child, and it takes its toll.
And obviously, the child matters most, and custody battles are notoriously expensive. How do you use your business background to help clients find financially sustainable solutions instead of draining their assets in court?
I think you have to lay out each fork in the road. Co-parent counseling, therapy, family therapy. Do you want to give that a try and see if it works? And, we can hit the pause button on the litigation. The next is, do we want to do a parenting psychological of the other parent? Do we want to, hire an expert? Do we want to hire a vocational expert? Here's going to be the cost of that. You're going to have a 2-day custody trial. This is, the projected cost of that. So you lay out each possibility, kind of give them a roadmap for each option, along with a cost benefit analysis of each option. And then, the choice is theirs ultimately. And some people, opt for, let's try therapy, let's see if we can work through this. And some people, and sometimes it's not the client, it's the other parent, and they know that that parent is never going to agree. So they say, you know what, we're going to have to go to court, because the only way they're going to agree to this is if the court orders it. So sometimes they would love to choose the other solutions, but it may not always be up to them if the other parent, the other party, is someone who has to have a court tell them this is the way it's going to be.
Well, as we wrap up today, when parents think they are just too far apart for mediation, what are the small bridge topics you use to start building a collaborative solution?
I think you start small. You start with things that you think you can get them to agree on, and then build up to the big issues. So let's say the parents cannot agree on a parenting schedule. Start with something small. Hey, do you think the two of you can agree on what extracurricular activities your child might participate in? And then, do you guys have an agreement on where your child would go to school? Is it going to be public school or private school? And if, let's look at the school in mom's school district. Let's look at the school in dad's school district, and, get them to agree on the school placement. And you sort of build up to the bigger issues. And sometimes when you do that, you start to see that, there's a change in their mindset of, oh, we're never going to agree on this, to, oh, look, you just agreed on extracurriculars, you agreed on school placement, you agreed on religious upbringing, you've agreed on holidays. Holidays usually aren't that hard, even when you've got parents who won't agree on an actual parenting schedule. So you get the holidays done. And then you're sort of on a roll of getting them to work towards a solution. And then you hit the big one, the actual parenting schedule.
Excellent. Well, that wraps up today's episode of Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. If you'd like to learn more about Melanie's work or schedule a consultation, visit melaniewallslaw.com. Thanks for listening, and don't forget to like, subscribe, and share the show so others can benefit from these conversations. Thank you, Melanie.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.